my lords, my lady. I was dealing with the top-down approach yesterday, and I was about to outline why we say my learned friend's grounds for distinguishing Napier are scrutiny. My learned friend seeks to argue, you can see this from paragraphs 47 and 48 of the skeleton, that Napier involved a unitary loss, whereas Textainer's loss was not unitary, and that is a ground of distinction. But in our submission, as I mentioned in outline to my lady yesterday, at the end of the session yesterday afternoon, that is a distinction that doesn't stand scrutiny. In Napier, there were a series of losses which, as at a given date, so the 36-month date, were added up and the credits were deducted and the net underwriting loss is ascertained. In our case, the losses occur, the individual losses occur on a rolling basis, and I'll come back to that later. And as and when they get in aggregate to a certain level, they crystallise a claim on the primary layer, and as they go up and reach other aggregate levels on the excess layers. So in our submission, in that sense, neither the loss in our case or in Napier is unitary, because they both involve a large number of individual losses. But to the extent that it's correct to categorise the losses in Napier as a unitary loss, that's because they're combined together at a given date and netted off against the credits to assess the net underwriting loss. I think, as my lady said yesterday, to create a balance of account. And in our submission, our case is exactly the same, in that each policy is engaged, as I said, when the aggregate of losses reaches a certain level. So one is going through a similar process of accumulating losses and credits, and at a given stage, whether it's the end of the net underwriting year or whether it's when the aggregate limits are reached, then you crystallise a claim on the policies. And alternatively, of course, as I said to my lords and my lady yesterday, it is possible to analyse the claim as arising when one gets to the preliminary claim date, so 6 months after the date of occurrence, or perhaps the final claim date. But either way, you will have a date on which the claim crystallises against each part of the programme. And my learned friend seeks to get around that, paragraph 48 of his skeleton, by arguing that the policy is in fact insured against what he calls individual container losses. And that's core tab 3, page 33. And that was again a phrase he used yesterday when he referred to individual container losses. But in our submission, that simply isn't a correct analysis of what is insured against or of the nature of the losses sustained. And that's because, as I said yesterday, each policy insures against a certain amount, layer or slice of the loss, rather than against any individual or particular containers. The programme does not insure against individual container losses, not least because, as my learned friend said yesterday, right, I think at the beginning of his submissions, the insured peril is in effect a lessee default. I think that was the phrase he used yesterday. And that fits neatly with the submission I made to the court yesterday based on the definition of date of occurrence. Occurrence is triggered by various events of insolvency of either the lessee or, if it had been a depot, the depot. And if the insurance was, as my learned friend suggests throughout his submissions yesterday, in relation to thousands of different containers and thousands of different losses, the first problem, of course, that we would all face, or my clients would face, is that none of those individual losses would reach the aggregate limit of any of the policies. In fact, none of them would ever exceed the retention unless one had the $5 million container, as my learned friend put it in his example yesterday, which I will come back to. And so that is another reason why it's wrong to seek to analyse these losses or the insured peril as relating to individual containers. And another reason in our submission, and this goes to a point my learned friend made yesterday and at paragraph 49 of his skeleton, claims were not made in respect of individual container losses. We made one claim pursuant to the provisions that I took the court to yesterday on each policy, again, many of these points lock together because they depend on the same things. But again, because the losses are aggregated and we make one claim accordingly, and we have to put our notice into after J. Gallagher the moment an event or occurrence arises, and then we have our preliminary claim and our final claim. And again, I don't think we need to go back to it, but in our submission that is supported by the definition of claim in the policy wording. What is insured by the programme is the aggregate of all our losses caused by a single occurrence. Would it help if we did go back? I see my lord looking back. It's core tab 13, page 164. And so how that would work in practice is that on considering all the different limbs of potential loss, on day one after the event of insolvency, or perhaps at the end of the first week, or perhaps at the end of the first month, depending on whether container rental was paid daily or weekly or monthly, we would suffer a loss of hire in relation to all of the containers. But that wouldn't give us claims in relation to any of those containers until the loss of hire got to 5 million. And we continue to suffer loss of hire day by day, or week by week, or month by month, depending on how often the hire should be paid.
Can I just go back to the point you were making a moment ago? And I think this is going over again ground you went over yesterday, and I apologise for that, but just so as we're all crystal clear about it. I think what it comes to is this, so far as the question of timing is concerned, is you acknowledge the judge's point that when one looks in the policy wording and sees the definition of date of preliminary claim, date of final claim, you say true it is that those definitions don't seem to work their way through into the operative clauses, but you say they're clearly there for a reason. It makes a rational sense. And I think what you were saying yesterday is that is in fact how the parties behaved when the claim was made.
My lord, I can't say that there was a preliminary claim because I couldn't take my lord to a document headed preliminary claim, but I did take my lord to the document headed final claim.
Yes.
But otherwise, exactly, my lord, subject to one nuance, which is this. The definitions didn't work their way through to any wording in relation to how claims are processed, because actually the policy lacks any wording as to how claims are processed, apart from the claim condition provisions at page 176. So we know that you have to give notice as soon as there is an event likely to give rise to a claim to Arthur J. Gallagher. We know that you have to give notice to the insolvent or potentially insolvent lessee, requiring them to redeliver the containers to you and requiring them to pay the monies owing to you. And we know from the provisions at the foot of page 167 that there's a period of 183 days which is engaged if containers are not recovered within that period. Give or take a day, 183 days is 6 months, which is the preliminary claim notification. So although it's, as my lord has said, far from clear, we do say that overall, when one looks at it, the structure that the parties intended it is.
Yeah, thank you.
So, my lord, I was working through how then that might arise in practice, and this goes to a point that the court raised yesterday. So we don't know whether these leases were for weekly or monthly or even daily hire, but for the purposes of this analysis, it doesn't matter. The hire is accruing day by day or month by month or week by week in accordance with the leases. The amount falling due each week or each month is probably reducing because, as we saw yesterday, some of the leases would be coming to the end. So whereas the hire payable, and may assist actually just to refresh the court's memory because I'll come on to this, but the hire payable as we see at page 6 of the supplemental bundle is reducing month by month by month. This of course is the claim against Hanjin, not against the policy. All the policies, but month by month, the amount claimed in respect to rental fees is falling, and I think it's safe to infer that's because some of the leases in default of which Hanjin is, are coming to an end month by month. So the hire is falling due month by month, day by day, week by week, and as and when containers are recovered, we may or may not incur a recovery cost when we actually manage to recover. And the court has seen the recovery costs claimed for. And I'll touch on these points now, but they're more relevant to the next point, but they fit here. And of course, recovery costs, there'll be a known date when we incur those costs. There'll be the invoices for the costs that we in due course have to submit to the loss adjuster to substantiate our claim in respect to the recovery costs. And if in due course a container is not recovered within whatever the relevant period is, and I'll come back to that, we suffer the capital loss of that container. And that may be if the preliminary claim date is the trigger date. It may be 6 months after the date of occurrence. It may be 12 months if it's final claim. It may be some other date when the loss adjuster and my clients agree that there's no longer any realistic prospect of recovering the containers. But there will be a date on which the container becomes a constructive total loss and that claim crystallises. So in one sense, having gone through that scheme of how the losses would fall in, it's correct that each individual loss erodes, as my learned friend says at paragraph 50 of his skeleton, the cover from the ground up. But it's not correct in our submission that this is on a container by container or individual container basis. It's simply as the losses accumulate, it's in the nature of the programme that they erode the cover from the ground up. And that's why in our submission, the simplified example, paragraph 51 of my learned friend's skeleton, which he took the court to yesterday, doesn't work. If I could just remind the court, paragraph 51 of my learned friend's skeleton, core, tab 3, page 33. He says to take a simple example with 2,000 containers, and he labels 1,000 of them the A containers and 1,000 of them the B containers. And they're all indemnified under the policy, or under, sorry, the second group are indemnified under the policy because the first group lost would be under the retention. If there's a later recovery of compensation in respect to the A containers, that recovery would not be applied on the basis of the top-down approach, it would be applied to the primary policy. And in our submission, that illustration doesn't work because it assumes the top-down approach isn't correct to prove that the top-down process isn't correct. If the primary policy is engaged when the A containers are lost, it's not because the primary policy is insuring the A containers. It's because the A containers are valued at the amount of the slice that the primary policy is insuring. And it's for the same reason that the $5 million container illustration doesn't work. If one has two $5 million containers, the first is lost, no recovery because the total loss is still only 5 million and the primary policy is not engaged. If the second 5 million container is lost and the primary policy pays out, it's not because it's insured the second container, it's because the losses have reached above 5 and up to 10 million. And so for all of these reasons, we don't agree that when individual losses arise, this gives rise to a cause of action. And I've been through the claims conditions, the preliminary claim definition and such like. I don't propose to go through those again. It doesn't take the matter any further. But if my learned friend is right and each individual loss gives rise to a cause of action, that would still not assist because they would be individual losses, wouldn't be individual losses relating to individual containers. You may have a loss of hire relating to all of the containers, then one may have loss recovery costs for some containers, then the total loss in due course for other containers. And each layer will be eroded, even on the learned friends analysis, by a mixture of claims relating to different containers. And so for any particular container, if one could find a container, one would almost inevitably see some of the lost rental being borne by the retention, some of the lost rental being paid by the primary, some of the lost rental being paid by the first excess, sooner or later a recovery cost being incurred and perhaps some damage to the container, which might be borne by the next layer up. And if the container isn't recovered, one might see the ultimate loss, the constructive total loss borne by yet another layer. So for any one container, it will affect any number of different policies.
But the lost rental will never be recovered.
No.
And neither would repair costs.
No, they wouldn't. But if the container was ultimately recovered, that would crystallise a recovery cost and perhaps a damage repair cost, which would be in the next layer, whichever layer was then the open layer, if I can put it that way. As one is burning through each layer, as losses fall in, you've got one layer that is bearing the next 5 million or 10 million worth of losses. And so if you get a recovery when you've burnt through the primary and the first layer, the third layer are notionally paying in relation to that recovery, but some of the lost rental has been borne by the first layer and the second layer, if it's appropriate to analyse it on a container by container basis. So this point is simply saying if it's appropriate to look at individual losses, it doesn't follow that any one layer is engaged by any one container, because losses relating to one container will impact on different layers as the loss goes up.
But just to understand, if there was a recovery of a container, if you were to seek to identify the loss against which that would have to be set, that would be against a constructive total loss of that container, which presumably, at least in theory, you could work out at what point in the chronology that had arisen, if that exercise had to be undertaken.
My lord, yes. So the containers for that purpose would fall into two categories. Those that were recovered before, can I assume for these purposes that the date of final claim as defined is when we crystallise the constructive total loss? Containers that were recovered before then are never treated as a constructive total loss. So you simply have a claim for the recovery costs, which falls on whatever layer is open at that time. Containers that are still lost at the date of the final claim, and we saw that from the schedule yesterday. I think there were about 9,000 containers still lost at the date of the final claim, and it went down to 8,000 into the next column. So there are some further recoveries. That then becomes a credit. We say all it does is reduce the aggregate from the top down. But if necessary, you would be able to identify which layer had paid the capital cost and which layer
What I'm not sure about at the moment, at what point is the constructive total loss formally claimed or acknowledged? Is it only when the final claim is made?
Well, my learned friend took the court yesterday to the definition in section 60 when it becomes unlikely there's going to be a recovery. The reason I took the court yesterday, and by way of recap this morning, through how the claim is structured, again, to stress, I have to accept that the definitions of preliminary and final claim are not carried through into any claims mechanism. But it does appear to us that what is intended is that a preliminary claim is made after 6 months, a final claim is made after 12 months, and if one looks at the wording at the foot of page 167, in the section that includes the heading lost equipment and repair and associated costs, and in the section that relates to equipment on hire, the closing words of the penultimate paragraph are "and not recovered within 183 days of the date of occurrence." Now, I have to accept, as I said yesterday and I've said today, that the language is not entirely clear, and it's not obvious from the wording on this page how it relates to lost containers. But it clearly is intended to relate to lost containers. As my lady said yesterday, the heading says lost equipment. And it seems to us that the best interpretation of this is that the parties are agreeing to treat containers that have not been recovered 183 days since the notice to the lessee was served are treated as a constructive total loss.
just to complete that, they're not relevant to interpretation. The way the parties actually dealt with it in the figures you took us to later suggests they may have sort of suspended that and looked at the position after 12 or even more than 12 months.
Well, indeed, my lady, and that's why I took the court to the definition, not just a preliminary claim, but final claim. And final claim is the date 12 months after the date of occurrence, or as may otherwise been agreed.
Yes.
And clearly, what happened at some stage, I can't tell the court when, the parties treated the containers that had not yet have been recovered as being lost for the purposes of the policy.
Yeah.
And it may not at that stage have mattered because it was so clear that the losses were going to burn through the whole of the tower that it didn't really matter whether the last few containers was 9,000 or 8,000. The loss was there, and we can see that from the loss schedule presented to the insurers, which we looked at yesterday. So supplemental bundle tab 5. This is the document that says final claim amount, September 2017.
Yes, although it's actually got this update.
Update in March. Precisely, my lady. But either way, the losses are so clearly in excess of anything written by the programme that it perhaps got to the stage where it didn't matter whether the last few containers were or were not yet agreed to be a constructive total loss.
But I think you explained yesterday that it was the figures in the final column, the one that said update to March 18, that were used as the basis of the final claim.
That is my understanding, my lady, and carried through into the learned judge's judgment as well.
Yeah. With the number of, effectively, the total loss revised with that slightly reduced number of unrecovered units.
Indeed.
You can make the point that this nightmare of uncertainty doesn't arise unless we get into the appellant's case.
Well, my lord, yes, and I did say in one sense the points I was dealing with, because I was looking at how the policy worked, that I'm slightly preempting the submissions I'm going to make later on this morning. But my lord, exactly that. What the parties did, the reason why I can't give the court answers to some of these questions is because the parties treated this policy, this tower, as paying up, and we're saying the natural corollary of that is that it recovers down. And that's the point I'm looking at with the top-down approach. And so, as I was saying, even if each individual loss gives rise to an individual cause of action, and we don't see how it can do because the cover is on an aggregate basis and you have to get to the aggregate limits before any of the cover is engaged, that doesn't assist because there may be individual causes of action notionally against any given insurer, but they're only liable to pay their slice at any given time. And it may be right, as my learned friend says, that each layer is eroded chronologically. And in fact, it may well be that each layer was all eroded on the same day, whichever the day was where one treated all the containers as a constructive total loss. But again, that doesn't take my learned friend any further, because in reality, each individual layer is paying up when the previous layer is exhausted. And that is why Teal, which is the case my learned friend took the court to yesterday, doesn't assist my learned friend, because in that case, Mr. Butcher was arguing that cover was only eroded when each previous layer had paid. And that is the point that Lord Mance dealt with and disagreed with. That doesn't assist my learned friend, because no one is suggesting that each layer is only exhausted when the previous layer is paid. Sorry, that the cause of action only arises when the previous layer is paid. The cause of action against any particular layer arises when the losses exceed the limit of liability of the previous layer. And that's why I took my lords and my lady to the no drop-down provision yesterday, which makes it clear that the cause of action against any one layer is only reached when the previous limit is approached or passed. So the first excess is not, or the primary or the first excess is not on any basis paying a loss related to identified containers. It's paying its slice because the cause of action arises against it when the aggregate gets to the limit of the layer below. But even if I'm wrong on all those points, and there are indeed, as my learned friend says, thousands of individual container losses, that's his point of paragraph 55, which he made to the court yesterday, that still doesn't affect it in our submission as a matter of analysis. The fact that what is insured and indemnified is in reality, again, it's the same point, but in a slightly different context, a slice or a layer of the overall aggregate losses. And my learned friend referred to a brief extract of my cross-examination of Mr. Chatfield yesterday. And if I could just ask the court to turn that up at core tab 6, page 24.
Supplemental.
Sorry, supplemental tab 6, page 24. And starting at the bottom left-hand corner, which is the bottom of page 122, I put the point that my clients presented the programme were presented as a whole, weren't they? So we didn't say, can we have compensation for this container or that container? We put it as a whole. Mr. Chatfield, when you say they were presented as a whole, can you explain what you mean by that? Question by me. They presented a lump sum claim for rental charges and a lump sum for repairs and a lump sum for repatriation. Then, well, we've got the schedules that show that, but obviously what they did was they submitted the Excel spreadsheets breaking down every container, every loss against each container. But they didn't claim each container against any particular policy, did they? No, they lumped them all together. And then the total figure claimed against the policy as a whole, yes. And then we had a small debate about the fifth excess. And then I said, and it was not a case that any claim in relation to a particular container or particular recovery was ever made against the insurer, was it? No. And I was putting those questions, not in the context of whether it was possible to establish dates. That wasn't any part of my case. I was putting those questions on the basis of how the claims were made against the policy. And Mr. Chatfield was agreeing with me. So essentially, what we see is a lump sum claim made that is then divided between the different slices, the different insurers, in accordance with the slices that they had agreed to bear. And that is why we submit that we're on all fours with Napier. So that's where I started, by submitting that it was not appropriate, there were no grounds for distinguishing Napier. That is why, in our submission, our loss is no more or no less unitary than the one in Napier. So I've been through all the different limbs of my learned friend's argument. And I would now...
Do you say that if an insurer wants to take the point at a future date, that recoveries should be allocated to the sums it has paid under its layer? It behoves it at the time it's dealing with the claim to ensure that it can identify what it is paying. It seems to me it's a bit much for an insurer just to pay on a pay up basis without clarifying or seeking to have clarified what it's paying against, and then to turn around and seek to claim recoveries when it hasn't identified what it was paying.
Well, my lord, yes, I can't quite go as far as to say whether it's incumbent on them, but if an insurer pays on a pay-up basis and then at a later date seeks to argue that the recover down doesn't apply, they are going to face the evidential problem that I'm going to come on and address.
It's an evidential issue, really. It's not, there's no stop or anything. It's just
exactly.
It's just that one would say that they've put themselves in the evidential difficulty because they have not allocated, that they've not ensured that they were paying against specific losses, if that's what they wish to claim.
My lord, almost exactly. The reason I just say not quite almost exactly is because one of the points I'll be making later is that, in fact, although the parties at the time were not focused on the chronology of payments, so the point that my learned friend is now making, they were focused on auditing that all the payments had been made and that the sums were all due. And Mr. Barnard, I'll come on to this later, but just so my lord sees where I'm going. Mr. Barnard gave evidence that there was, as one would expect on a loss of this size, a lengthy process of negotiation with the loss adjusters. it wasn't just a very large spreadsheet. There was a large amount of supporting documents, which no doubt would have included invoices and such like for expenses that were incurred. And so the only reason I'm slightly disagreeing with how my lord put it is because you might not care about the dates, but still get all the evidence that would in due course allow you to establish the dates. And that's the position we say we're in this case, that at the time of the claim, nobody really cared about the dates because the policy was paying up and would in due course recover down. They didn't focus, as my lord has said, on that. If they had have done, it would have been very easy for them to come along and say, well, I paid this loss and so paid this loss. But it's still possible for them to do that because they do still have all that information. And this goes to a point Lord Justice Arnold raised yesterday about disclosure. When this all became relevant, and I'll look at this in more detail later, it wouldn't even have been a question of the insurers saying, well, can we have disclosure of this, this and this? They've got the spreadsheet, they've got all the documents that underlie it, or at least their adjusters have. If they wanted to look and say, well, this is when all the recovery costs were paid, or this is when all the containers were constructively lost, or this is when all the rental income was lost, it's within their power to do so, but they've chosen not to. But I'm running ahead of myself slightly, but I hope that's helpful, my lord. So I'm not saying it's incumbent on the sense of any estoppel or such like, but it's an evidential point that, if I can put it this way, will come back to haunt them if they don't do it correctly. But the reality...
Well, you can say, this is jumping ahead, but you can say that the court shouldn't draw an inference if a party has chosen not to adduce the evidence, which would have meant it was not necessary to draw that inference.
But that's precisely one of the points I'll be making later on, yes. But it's useful to pick it up now while we've been looking at how the losses were paid. And so, having gone through my learned friend's grounds for Napier, if I could just ask the court very quickly, I hope, since we did look at it yesterday, to look at Napier both in the Court of Appeal and the House of Lords. So, authorities bundle 10.5. I'm going to go straight, if I may, to the judgment of Lord Justice Staunton, but pausing to say that Lord Justice Dillon reached precisely the same conclusion for basically the same reasons. But Lord Justice Staunton dealt with the averaging point, which Lord Justice Dillon didn't, so it's useful to look at his judgment. Bundle page 74, report page 23. Lord Justice Staunton started in the left-hand column by quoting from Castilian. We've got Castilian in the authorities bundle. But the passage beginning at the very foundation, in my opinion, of every rule which is applied to insurance law is this. No contract of insurance contained in a marine or fire policy is a contract of indemnity, and of indemnity only. And that this contract means that the assured, in the case of a loss against which a policy has been made, shall be fully indemnified, but never be more than fully indemnified. So, and Lord Justice Staunton emphasised the word in a case of a loss against which the policy has been made. And my lords, my lady will see where I'm going to on this, because that's essentially the wording, again, that we saw in the recoveries condition. Recoverers fall to the insurer in respect of a loss that has been indemnified. So Lord Justice Staunton then says the emphasis is mine for reasons which will appear, and then on the right-hand column we see the parts of the judgment that my learned friend read to the court yesterday. I don't intend to go over them again. The only point I would say, while we've got it open, to opening it later, and this point goes more to the averaging point than anything else. When Lord Justice Staunton dealt with the averaging point in the paragraph beginning we were referred to, he's referring to the text the court's referred to on averaging. The problem there considered is that of underinsurance, where property is insured for less than the value. The authors do not appear to touch upon liability insurance, and this is the wording I said yesterday, my learned friend skipped lightly over brackets, in this case unlimited liability. And the importance of that is that when one is looking at excess of loss, the potential liability is unlimited and can't be assessed at inception. So I'll make that point now while we've got it open, and I'll come back to it when we're averaging. Anyway, we've read through the rest of what Lord Justice Staunton said. But just to remind my lords, my lady, at page 75, I will allow this appeal on the second issue. So this is the top-down issue, and this is where Lord Justice Staunton says that pay up, recover down puts it accurately. And then moving on to Lord Templeman in the House of Lords, again, a judgment with which all the other law lords agreed, including in particular Lord Chauncey, who also analysed the problem. But you were taken to, I think, page 93. And again, the important passage begins at the top of page 93 of the authorities bundle. Page 730 of the report. The problem must, in my opinion, be solved. And my learned friend read those paragraphs to you yesterday. But can I just emphasise, between letters B and C, what we say is the crux of the judgment. The third insurer is entitled to be the first to be subrogated because he only agreed to pay if the first two insurers did not cover the total loss. That is the crux of the entire matter in our respectful submission. And it applies equally to a programme of excess insurers that the court is concerned with, as it did to the stop loss insurance in Napier, as it did to the aircraft insurance in KAC. The reason why the first slice of a recovery goes to the insurer at the top of the tower, or the programme, whatever wants to call it, is because that insurer only agreed to pay the slice at the top. And again, that's why I took the court to the no drop-down provision yesterday. Even clearer. And so one could look through.
Sorry, just the no drop-down provision. Are you saying that simply reinforces that point?
What it does is to reinforce the point that an insurer at any given level has not just said, I'm only going to pay above a certain limit. They've gone to considerable lengths to say, and whatever happens in the layer below me, I'm not responsible for that. My cover will not drop down to the layer below. So yes, reinforces is possibly the best way of putting it, my lady. And one could adjust Lord Templeman's example, which he's giving from letter B through to letter D. He's dealing with three insurance companies, as he's postulating there, because he's treating the uninsured top slice as one insurance company, the stop loss level, the 100,000 as another insurance company, and the retention as another insurance company. One could simply postulate 8 insurance companies and then adapt Lord Templeman's wording, which would be that the 8th insurer, in our case, the 8th insurer is Textainer's uninsured portion, is entitled to be the first to be subrogated because he, that's Textainer in this situation, only agreed to pay if the first 7 insurers did not cover the total loss, and one could use that exact phrase again and again down through the programme. And then another reason in our respectful submission for applying the top-down approach, as well as the fact that it is the only approach that respects the commercial bargain that the insurers have made, it goes back to the citation from Castilian that I took the court to in Lord Justice Staunton's judgment. And that's that applying the top-down approach most closely conforms to the underlying rationale of subrogation. Those aren't my words, they're the words of Mr. Justice Ricks, as he then was, in KAC and KIC at page 695 of the report. And that's in the first judgment at page 148. We went to Mr. Justice Langley's judgment later on in this case, but at Divider 70 of the authorities bundle, page 148. Mr. Justice Ricks, in the left-hand column, has looked at Napier, has looked at what Lord Templeman said, has looked at similar passages to those that Lord Justice Staunton was shown from Goff and Jones, but from a newer edition of Goff and Jones, dealing with sections 79 and 81. And then says at the penultimate paragraph, it seems to me, however, that KAC are entitled to the benefit of the top-down principle, either because it is the principle which most closely conforms to the underlying rationale of subrogation, or because any variation from that principle is confined to marine insurance. and I'll have to come back to the is confined to marine insurance later when we look at averaging. But the reality is, the passage I took the court to from Castellian makes it clear that the insured should be entitled to an indemnity, no more, no less. And unless the insured keeps the recovery in respect of the uninsured portion of the losses, they do not get a full indemnity. So that's why the recovery should start with the very top slice, whether that is borne by an insurer or by the insured. Mr. Justice Ricks, in his judgment, made no judgment as to how the top-down approach would actually work in practice on the facts of that case. That was left to Mr. Justice Langley in the subsequent judgment. The court has seen at Divider 10 of the authorities bundle. And as my learned friend took the court to yesterday, under the heading of the aircraft by aircraft approach, Mr. Justice Langley dealt with figures, and then at page 185 of the judgment, under question 1, following the judgment of Mr. Justice Ricks, it's no longer in dispute that all of the aircraft and all the spares and equipment were totally lost by one occurrence, nor is it or can it be contended the top-down principle does not apply. Just pausing there if I can. Mr. Justice Ricks's judgment on other points had been appealed, and indeed appealed all the way to House of Lords, but not his judgment on the application of the top-down principle. So, insofar as my learned friend seeks later to go on to say Mr. Justice Langley is wrong to apply the top-down principle, it was in fact Mr. Justice Ricks who said it applied, and although other aspects of his judgment were appealed all the way to the House of Lords, that part of his judgment was not. And then at page 186, the judgment of Mr. Justice Langley, and again, my learned friend took you through this yesterday, I'm not going to repeat that, other than to point out at 261 of the report, right-hand column at the top of the page, the words beginning, the effect of the insurer's submission is that the aggregate limit of 300 million only applies in limited circumstances where there are no recoveries, but otherwise is an unpredictable figure depending on recoveries and their value. And I think that's a point, I think it was my Lord Justice Phillips picked up on yesterday, but forgive me if I'm wrong in that, but that was raised with my learned friend yesterday. If one doesn't apply the top-down approach, one is essentially putting a line through the contractual agreement that the parties have reached as to limits payable by each insurer. And that's essentially the same point as Lord Templeman made in Napier. So, we submit that there's no grounds on which to distinguish the decision in KAC. If anything, our case is more clearly one of top-down than in KAC, because we have a full tower of insurers, and because it is at least arguable in KAC you had a limited number of identified aircraft, and although they were all lost on one day, it would have been much easier to say aircraft by aircraft. In fact, we saw that was the phrase that was used, aircraft by aircraft. Much more difficult in our case to say container by container. But my learned friend says, paragraph 57 of his skeleton, there are two grounds for distinguishing KAC. The first, he says, is that the aircraft were all lost on one day. Well, true, that was Mr. Justice Ricks's finding. It was upheld on appeal. Whereas he says our losses took place over a period. Again, true, but subject to the possibility that, in fact, they all became claimable on the preliminary claim date or the final claim date. But that doesn't assist, because, as the learned judge said, and just for the court to note, it's paragraph 92 of the judgment, core bundle 8, page 108. It was no part of Mr. Justice Langley's reasoning in reaching his conclusion that the top-down approach applied, that the aircraft were all lost on the same day. His reasoning, as I've just emphasised to the court, is that if you don't apply the top-down approach, you've rewritten the commercial bargain of the parties. The second ground of distinction the learned friend puts forward is that in KAC it was aircraft that were recovered, not money. With respect, again, that's a distinction without any substance. it's true that only aircraft were recovered, but the reason that doesn't make a difference is twofold. Firstly, in our case, although the court is concerned with the money recovery we made from Hanjin, as I took the court to yesterday, there was a substantial recovery of containers, both before the date of the final loss and further containers recovered afterwards. And the money value of those containers was credited against the overall claim. And secondly, of course, something of a truism to say, in KAC, the insurers were not asking for the aircraft. They were asking for the money value of the aircraft. So the fact that the recovery had been in the form of aircraft simply translated itself into money terms. And so we would suggest that, like Napier, there are no grounds for distinguishing KAC, which leaves my learned friend's submission that it was wrongly decided. And in our submission, that is not the case. Firstly, it's on all fours with Napier. Napier is binding House of Lords authority. If Napier is good law, as my learned friend accepted is, then so is the decision in KAC. And secondly, my learned friend said, well, Mr. Justice Langley only gave two reasons for his judgment, and that's true. He found himself on two key points. The second is the one I've taken the court to. But there may only be two reasons, but there are two in our submission very good reasons. The judgment is right for the reasons Mr. Justice Langley gave. But thirdly, and my learned friend predicted that I would make this point, the learned editors of Arnold on marine insurance deal with this at some length. At paragraph 31-46, which the court has at page 238. I don't propose to take up time by reading the whole passage, but I would invite the court to read paragraph 31-46 onwards, because what the learned editors do here, and I should stress that this is a passage that's been in every edition of Arnold's since the 2008 edition without material change. So it's a passage in a leading textbook that has stood the test of time. And what they do is look at Napier, look at the Commonwealth, identify, and I'll come back to this when we look at averaging, identify that there is an argument, as my learned friend makes, that there can be a tension between an excess of loss programme that was not marine insurance related and the provisions of section 81. And when I deal with averaging, I'll explain why in our submission that there isn't any tension. But the learned editors look at that point. It's the same point that troubled Lord Justice Staunton, although not for long. And then they say this at page 239 of the bundle. The effect of the decisions in the Commonwealth and Napier and Hunter, and they've made the point that in fact the Commonwealth wasn't referred to in Napier and Hunter, is therefore submitted as follows. One, in the case of a partial or underinsurance on a marine policy, where the insurance covers the assured's interest in the subject matter as a whole, but the cover provided is less than the insurable value of the agreed value, average will apply to determine the respective interests of the insurer and the insured. So, insurer and the insured, that's the Commonwealth. In a case of a partial or underinsurance where the insurance covers the assured's interest in the submatter only insofar as his loss exceeds a specified sum, so that's the excess of loss policy, whether under a stop loss or excess of loss contract, or by virtue of a deductible or some other form of cover. So the learned editors think there's no distinction between whether you're looking at stop loss or excessive loss or just a large deductible. Any recovery must be applied first to the loss above the specified sum, so that the insurer above that sum has priority, the insurer below the specified sum. Then they say that the matter is not entirely free from doubt. That's a reference to the comment Mr. Justice Ricks made in KAC. But over the page, page 240, but picking up again, if I can, 5 lines into page 240, the judgment of Lord Justice Staunton in the Court of Appeal in Napier and Hunter expressly, and the speeches of Lord Templeman and Jauncey in the House of Lords implicitly, indicate that the point of distinction in that case was not between marine and non-marine policies, but rather the nature of the cover that the top loss policies provided. So again, essentially the reason the top-down approach applied was not because it was a non-marine policy, it was because of the nature of the stop loss insurance, and that's clear. Moreover, a top-down approach would appear to be inapplicable under even a non-marine policy when the same is subject to an average clause. And then just reading down to the end, submitted that any distinction between marine and non-marine policies in this regard should therefore be confined to the proposition that marine policies are subject to a presumption of average under section 81, while non-marine policies are not. But a marine policy may attract a top-down approach to the allocation of proceeds of recovery where the nature of the policy demands it. And in our submission, in a case such as this, providing for insurance by layers, the policy demands it, because otherwise the bargain of the parties is not respected, and therefore the top-down approach is applicable. And on that, unless I can assist further, those are our submissions in relation to the top-down approach, and I'll move on if I can to deal with inferences and assumptions. The inference that the claimants contend is that the operating and financing losses were suffered evenly or in a regular and consistent fashion, rather than finance leases first, possibly, and operating leases later. One sees that from paragraph 2.5 of the Notice of Appeal and paragraph 104 of the judgment. Put another way, as they do in their skeleton at paragraph 33.1, that the losses were suffered regularly and evenly over time. I've already dealt with the submissions, and as I've expanded on this morning, if my lords will forgive me, my lady, I'm just going to check some parts of my notes that I've covered this morning. I've covered the submission relating to whether there are individual container losses being suffered, and the losses eroded container by container. I'm not going to go back over that. But what my learned friends say, paragraph 33.3 of his skeleton, is that the contribution of the policy's indemnities, the operating leases losses, and the finance lease losses were proportionate to the value of the layer as a whole. And in our respectful submission, that doesn't get him any further, because that depends on him being right about the top-down approach. And if he's wrong about the top-down approach, that point doesn't help. But even if he's correct that layers or slices indemnified individual losses, that still doesn't go far enough, because he still has to establish the coincidence, as I said to the court yesterday, between the loss that any given layer has indemnified and the recovery that is being made. And so we respectfully submit that on this point, the learned deputy judge was correct when he dismissed the application for permission to appeal, to observe, I don't think we need to turn it up, it's tab 9 of the core bundle, page 125, that he had made a finding of fact at paragraph 107 of his judgment. That finding was that the claimants had not discharged the burden to connect any particular loss indemnified by a particular policy to a particular recovery. That was a factual conclusion.
Well, that's not disputed.
And
nor is it disputed that the rigours applicable to a challenge to a finding of fact apply to this one as to others. Subject to this, the point is made that when it's a question of what inferences may properly be drawn from such primary facts as have been found or not found, then it's not so hard as where it's based on, for example, evaluation of oral evidence.
Those were exactly the points I was going to make. So, but my lord, moving on then, and I'm grateful to my lord for, as it were, summarising. The background to this issue, and this is important if the court will forgive me, is that in the original particulars of claim, no claim of the kind put forward was now advanced. The claimant's claim, on an entirely different basis from that now relied upon, was that the insurers were entitled to the whole of the recovery in proportion to their various slices, and that Textainer was only entitled as assignee of the fourth layer, because at that stage they disagreed with our suggestion we were assignee of the fifth layer as well. To anything in that capacity, we got nothing in our uninsured context. And one can see that, I hope we don't need to turn it up because I hope it's not contentious, but one can see that in particular from paragraphs 17 and 19 and 24 of the unamended particulars of claim. The court doesn't have the unamended particulars of claim, but in the usual way, the court can discern the amendments from the colour in the document that the court does have, or from the underlining at core tab 11, page 142 onwards. But just picking up on one of those cross-references, if I can, paragraph 17, at page 147. The case then was simply all the recoveries went to the insurers and were then divided between them proportionately. By amendment, which one sees at paragraph 17, we can ignore the first amendment in the second line. That arose out of the representation issue. The second amendment is or such proportion as the court may determine. There was no actually particulars given as to what proportion my learned friend would invite the court to determine. But that phrase, or such proportion as the court may determine, was added by re-amendments, made 2 weeks before trial. So the issue in respect of which my learned friend now depends crucially on an inference only arose by amendments made 2 weeks before. There's no issue but that it's open to him to take that point. It was open to him before the judge. And even though he didn't plead particularly what proportions he was going to contend for, I didn't suggest he couldn't advance this case. But it is important background to the evidential difficulty that he now finds himself in, and the appropriateness of asking the trial judge, still less this court, to draw inferences, not inferences based on such evidence as there is, but inferences based on a lack of evidence. And as I mentioned earlier this morning, and in response to the disclosure point my Lord Justice Arnold raised, he didn't even need to ask us for disclosure of the relevant documents. His clients have the spreadsheet, they have the underlying documents, or at least their adjusters do. And if I need to substantiate that, it's paragraph 43 of Mr. Barnard's statement at the supplemental bundle tab 4, page 16, but I don't think that's in dispute. So our submission is that insofar as my learned friend is in difficulties, because there is a lack of evidence, that is of his own making. And in support of that, I rely on 2 particular points.
So there's a phrase that comes to mind. I think it's Lord Bingham in a case in the House of Lords called Fairhaven, in which he quotes a statement, I think it's Lord Mansfield, about how proof depends upon, I forget the exact words, the extent to which each party is able to adduce evidence. So to the extent that you are able to adduce evidence, then the onus is upon you to do so. And I think that is the fundamental proposition on which you are relying here, are you not?
My Lord, yes, but perhaps with a slight nuance to it, which is that we're talking about inferences, and therefore the extent to which it's appropriate to invite a court to make inferences will be influenced by the extent to which you would have been in a position to lead evidence had you chosen to. So it's a slight nuance on my Lord's point, but it's basically the same point.
Yeah.
Well, where a party chooses not to adduce evidence on a point, the court will normally may reach an inference in the opposite direction. And it would be a very strange position if a party could invite the court to find a factual scenario on inference when they had chosen not to adduce the documents which could have demonstrated as a matter of primary fact. And indeed, it would be a very dangerous course, because it would mean that parties could actually mislead the court in that way.
My Lord,
I'm not saying that's what's happened here, but
no, my Lord, I'm certainly not going to suggest that here, but it does lead to one important point, which I'll take now. I was going to come to in a moment. one of the points my learned friend made obliquely in his skeleton, but it absolutely clearly yesterday, he said to the court, the schedule, the spreadsheet, does not show the dates of the loss. Now, that simply isn't a point with respect that is open to make, because the spreadsheet isn't here and the court doesn't know. He relied on, in support of that, the points, the cross-examination of Mr. Barnard that he took the court to in supplemental under tab 6, page 25. And he covered the fact that it's a massive spreadsheet with Mr. Barnard, and we looked at that yesterday. And he relied on my questions that I put to his instructing solicitor, which I took the court to earlier this morning. But I didn't ask his instructing solicitor anything about the dates. That wasn't any part of my case. The significant point, and this is a point I relied on in my closing submissions to the judge, and I rely on today as well, is that my learned friend did not put to Mr. Barnard, when he questioned him about the spreadsheet, the point he asserted to the court yesterday, is that the spreadsheet does not show the date. He dealt with the fact it's a large spreadsheet. He dealt with the fact that there's an individual entry for each container. That much is all common ground. But he didn't put the case he's now put, which is that one couldn't discern from the spreadsheet the dates of the individual losses. And this goes back partly to the point my Lord Justice Phillips raised earlier. And we say there's nothing untoward about that. We don't criticise anybody for that, because at the time the parties treated the policy as paying up, and they should now treat the policy as recovering down. And it's my learned friend that wants to, as it were, compare apples with pears and pay up and recover on some other basis. But it is an unfortunate aspect of his case that he is now seeking to advance factual assertions, a factual case that wasn't put in my words. But the reason, just to go back to where I was in my submission, that it's important that this matter should be dealt with by evidence rather than by way of inferences, is firstly the recoveries condition that I took the court to yesterday, that requires the insurers, the burden being on them, to establish that the recovery has been made as or towards any part of the loss that they've indemnified. And therefore, in our submission, they need to establish that by way of evidence. And even if he can say, well, the hand-in recoveries is 40 cents in the dollar, and therefore, in that respect, it is pro rata across everything. That's simply how the hand-in recovery was dealt with, as between hand-in and my clients. That doesn't get him anywhere close to where he needs to be, for two reasons. Firstly, as between my clients and the insurers, the hand-in recovery is still just a money recovery against our overall loss. And therefore, if we're right on top down, it doesn't help my learned friend at all. But secondly, even if I'm wrong on that, and one could treat the hand-in recovery as meaning that 40% of every loss relating to an operating lease container has been recovered, that doesn't help him unless he can get his second point through, which is that the operating and finance losses were suffered not just regularly, but in a regular pattern that reflected each other, i.e. that the finance lease losses were not suffered earlier and therefore impacted those he represents rather than the other parts of the programme. The second reason it's not appropriate in our submission to deal with this matter by way of inferences is that whilst the authorities clearly show a municipal and mutual that my learned friend took the court to yesterday is the best example of this, that in circumstances it might be appropriate. And the word used in Arnold that my learned friend took the court to yesterday is it may be appropriate to draw inferences. The court still has to assess whether it is. In municipal and mutual, there were, of course, 2 excavators, and they were damaged across a period of time. The owners sued the Port of Sunderland and won damages of £1,765,000. So there had been a trial between Sunderland and the owners about how and when this damage occurred, and the judgment from the trial and some of the evidence from the trial was available to the court. My lords, my lady, have been shown the judgment and are aware of why the issue arose. It arose in the context of the claim against reinsurers. The reason why the Court of Appeal was dealing with facts is because the trial judge, Mr. Justice Waller, as he then was, had decided an averaging point one way, and the Court of Appeal went the other way. So the factual issue hadn't arisen at first instance, and the Court of Appeal, having overturned him on how the excess applied, then had to look at whether the excess had been exceeded in relation to any of the preceding years. But the crucial thing in Municipal Mutual is that there was evidence, as the court will record it. May assist just to turn it up in the authorities bundle at divider 9. Picking up, if I can, at page 175. There was a document, an inspection of the cranes, document recording the inspection of the cranes in March 1987. Sorry, I've given myself a wrong reference, page 165. Right-hand column at page 165, we pick up there that in March 1987 there had been an inspection which had revealed some minor pilferage but nothing serious. And so up to March 1987, nothing serious. One then sees later on in the same paragraph that when a representative inspected the dragline parts in September, they were still there then. He found they'd been extensively damaged by theft and vandalism. So September 1988 is the end date. So in between, so the court say with some confidence that in between March 1987 and September 1988, the damage in respect of which the Port of Sunderland was sued all occurred in that period. But also, when one then goes forward to page 175 on the judgment, there was picking up, my learned friend did take my way to this passage. And it begins, the facts must be taken from the judgment of Judge Stevenson. And a few lines further, at the other end of the period, in especially September 1988, there had been very extensive pilferage. And then Lord Justice Hobhouse observes at the bottom of that paragraph, I consider the inference is justified on the balance of probabilities, loss or damage will continue to occur throughout the period, and by a third contract, into the period covered by the third contract. Indeed, it's to be inferred that the thieves, having discovered a source of pilferable material, would not be letting up in their efforts to steal as much of it as they could. And then there's a lengthy discussion in the next-hand column at page 437, including a reference to the document in July 1987, so partway through that period. And the Court of Appeal clearly had a reasonably large amount of evidence as to what was happening from which to draw inferences. And one can reality check what's happening there. Short of having evidence from someone at the port that had observed the pattern of the theft but not done anything to stop it, or confessions from the thieves who had been stealing all the equipment, you could never have clear evidence as to when the losses occurred. But what you could do, which is what Lord Justice Hobhouse did, was look at such evidence you did have, knowing that you had all the available evidence, because you had the evidence that was before the judge who had given judgment against the underlying assured. So you know you've got all the evidence, and it's sufficient on the balance of probabilities to justify sanction. And that is a very different case to our case, where you know you don't have all of the evidence. And in our submission, therefore, it's inappropriate to proceed on the basis of inferences. And again, my learned friend, I said already, showed you Arnold at page 241 of the bundle. I don't think we need to type it up. All that learned editors are there saying is that in appropriate cases, the court may proceed by way of inferences. That doesn't, with respect, assist this court in deciding whether it is appropriate. So we invite you to reject the suggestion that it would be appropriate to draw inferences in this case, and certainly that it would be appropriate to draw the inferences that my learned friend contends for, because they are all or nothing inferences. He accepts that if he can't establish that the finance lease losses were suffered in a similar pattern, or the same pattern in fact, to the operating lease losses, then this part of his case doesn't get home. And what I would like to do there is just deal with the 5 particular points that my learned friend makes in his skeleton. So if the court just give me a moment just to check my note. And so I'm picking up for the court today paragraph 77 of my learned friend's skeleton argument. Which is core tab 3. Page 39. And in this paragraph and following, he makes 5 headline points. So just by way of summary on my submissions on inferences, I'd like to deal with each of those if I can, so the court has our response. First of all, at paragraph 77, he submits that the spreadsheets itemise the quantum of the individual losses, which is true, but that's where he then goes on to say, but not the date of such losses. But for the reasons I've already submitted, my lords and my lady, that's not correct. There's no evidence at all that they don't show the date. He could establish that by putting them in. He didn't put that to Mr. Barnard. And he then says that if the spreadsheets had identified the dates of each loss, that would have been attributable to each particular layer. Of course, that submission assumes, which Mr. Chatfield agreed was not the case, that the parties were treating the policies as paying against individual losses at the time. And Mr. Chatfield, in fact, as I've shown the court already, confirmed in cross-examination that was not the approach that was taken at the time. So his concluding comment at paragraph 78, he says, this can only be because the date of the loss was not identifiable. It is simply in our respectful submission a non sequitur. The reason why the parties weren't identifying losses at the time, dates for losses at the time, is because they didn't believe they needed to, which was the point I put to Mr. Chatfield, not because it wasn't possible to identify the dates of the losses. And equally, he goes on at paragraph 80 to say there was no indication in the evidence that the date of each individual container was set out in the spreadsheet. But again, that's assuming what he has to prove what he has to prove. There was no evidence the other way round. So on that point, if my learned friend wanted the judge, or invites this court to infer, in the absence of evidence as to dates, that the losses were suffered evenly, he should have led that evidence. Secondly, paragraph 81 and onwards of my learned friend's skeleton, he submits that the schedule supports his case, in that he says it shows that the rental fees were in fact suffered on an even and regular basis. And we do then, I'm afraid, need to turn that schedule up again, because not only do we disagree with that suggestion, we respectfully submit the contrary is true. So supplemental bundle, tab 2, page 6. And my learned friend makes a point in relation to each of the columns, so rental fees, recovery costs, and unrecovered costs. And he makes those in the 3 sub-paragraphs of paragraph 81 of his skeleton, and I'm going to take each in turn. First of all, rental fees. What we see in relation to rental fees, as I've said to the court already, is month by month the amount of loss suffered goes down. No doubt because the leases are falling in. But crucially, what we see is that the finance lease losses in every month are substantially higher than the operating lease losses. So what that tells us, insofar as this document is evidence of anything, so I'm arguing against myself in one sense, because the court has my primary submission that in the absence of the actual evidence, we shouldn't be engaging in this. But if we were going to look at the documents we do have and say, well, what inferences might they support? This document in relation to rental fees suggests that at the beginning of the period, a higher loss was being sustained for finance leases than for operating leases. And so at some stage, if one was just looking at the rental fees, at some stage in September 2016, the uninsured portion, the retention is burned through. We exceed 5 million. So we cut into the primary lag. And a greater proportion of the losses are finance lease losses. The same is true in the second month. And during the course of the second month, we would be burning through into the first excess layer because the total of the first and second months exceeds 10 million. But again, a greater proportion of the losses, certainly of rental income, are finance lease losses. And that pattern repeats itself right through until February 2017. So what that shows, what this document shows, if anything, is that finance lease losses are being incurred earlier in the chronology. What that inevitably means is that those my learned friend represents, the primary, first, second, third excess layer, would be paying disproportionately against finance lease losses. And that, of course, is the opposite of what he needs to establish to be entitled to any part of the recovery. So such evidence as there is actually counts against my learned friend's influence. He then makes the point, his second point, his second subparagraph of paragraph 81, relates to the wording against the asterisk for recovery costs, where my clients have advised Hanjin we are unable to break out per unit expenses per month, as most units had multiple expenses that occurred over a time period greater than 1 month. And he says, aha, that shows that you can't allocate the costs per month. And with respect, it says nothing of the sort. What it says is, for any one container, we can't say that container's losses were suffered in any given month, because for any one container, we paid a recovery cost in 1 month and some damages for repair in another month. So all it's saying is we can't, for any one container, put all the losses into 1 month. It doesn't mean what my learned friend needs to get to, which is that you couldn't allocate the costs. And again, one stands back and looks at the commercial reality. Would these insurers, assisted by their loss adjusters, have paid any of these costs if they were not supported by invoices? Answer, almost certainly not. Would these invoices all have a date on them? Answer, almost certainly yes. Could the court therefore ascertain the dates on which these losses were incurred? Answer, almost certainly yes. Who has that evidence? Answer, the claimants. And then we come to look at the unrecovered book value. That's the third column, which my learned friend deals with at paragraph 81.3. The first point my learned friend makes in relation to that is that all the schedule does is give the book values as at February 2017. Well, that's true, and as we said yesterday, I said that there was a reference to it in the judgment to make good the point I made. Paragraph 18 of the judgment, the judge records the reason why February 2017 was taken as the date is because that's what the trustee in bankruptcy had asked my clients to do, is to give the value as at that date. All that means is that as at that date, as between my clients and the trustee, the containers were being treated as no longer recoverable. And one can see that from the wording of the settlement agreement at Supplemental Bundle tab 3, page 7, because we transferred title to the unrecovered containers. In this respect, the unrecovered operating lease containers to the trustee. Paragraph 2 was the agreement by which he could recover any remaining containers. And so, again, looked in the context of the claims conditions that I took the court to yesterday and earlier today. As between my clients and the insurers, what is said in this schedule really tells the court nothing about what losses were indemnified by the insurers. Because, and we did this exercise yesterday, I'm not going to repeat it, but if we flick through to page 23, we see that first of all, whereas the value put forward against the trustees was 80 odd million for unrecovered containers, the value claimed on the policy was substantially less than that. Unrecovered units is 21 odd million. So apart from anything else, one knows that for insurance purposes and recovery purposes, containers are being valued on a very different basis. But either way, what is significant, as far as there's any significance from this schedule, in our submission is this: that unlike the rental fees, when one looks at the value as at February 2017, the value of lost operating lease containers is substantially more than the value of the lost finance lease containers, 48 million against 32. Now, obviously I accept this is as at February 2017. So that's the date of the bankruptcy. That isn't any of the dates which I have suggested to the court might be the date for crystallising the unrecovered loss claim against the insurers. And again, just to recap, that's either the preliminary date, 6 months, or the final claim date, 12 months, or such other date is agreed. What it does show, however, is that in terms of the capital loss, that is predominantly operating loss containers. And what that indicates, insofar as it indicates anything, is that the loss in respect of operating containers would be felt at the end of the period during which the programme has been paying out. So once again, that and that's because the date on which the containers are assumed to be or treated or agreed to be a constructive total loss comes at the end of the period. Whether that's February 2017 or whether that's the date of final loss doesn't matter for the purposes of this submission. And so that element of the loss, the one that comes at the end rather than throughout the period, is predominantly operating loss, lease losses, which again is precisely the opposite of what my learned friend needs to achieve by way of his inference. So insofar as this document tells you anything, it tells you that the inference should be the opposite of that which my learned friend invites the court to make. And therefore, going on to paragraph 83 of his skeleton, in our submission, it's simply wrong for my learned friend to say that there was evidence before the court that operating and finance leases losses were suffered regularly and consistently through the loss period. Such evidence as there was, in fact, is to the contrary. And insofar as the evidence didn't get to a conclusion, again, as I've already submitted, that's because the detail of the evidence has not been put before the court. So in those circumstances, for that reason as well, the learned deputy judge was entirely correct not to make the inferences that my learned friend has invited him to make. The third point my learned friend makes, paragraph 84 of his skeleton, is that the learned deputy judge was wrong to find that claimants had made no attempt to identify the date of the loss. But with respect, that's a bad point. All the learned judge meant by that in his judgment is that they hadn't put in the kind of evidence I've been debating with the court today. Yes, they had referred to that schedule. So in that limited extent, the claimants had sought to identify the dates of the loss, but beyond that, they hadn't done so. And so my learned friend's third point is a bad point. His fourth point, which he makes at paragraph 85, is that there was no evidence before the court that the finance lease container losses, or a large number of them, occurred before the operating losses. Well, with respect, we simply don't understand that submission because it's reversing the burden of proof. My learned friend wants the court to draw an inference, and he says, well, in support of that inference, there's no evidence before the court to the contrary. But the correct analysis in our submission is, firstly, the lack of evidence doesn't assist my learned friend because he could have put in the evidence to establish the inference. I've made that point already. And secondly, which is why I've had a look in some detail at the schedule, insofar as there is evidence, in fact, there is evidence that suggests that the finance leases losses were suffered first. And in relation to that, again, my learned friend at paragraph 86 says it's inherently unlikely that that would be the case. And we simply don't understand the basis for asserting that it's inherently unlikely that would be the case, partly because the evidence I've taken the court to this morning shows that it probably was the case. Then he says, indeed, the schedule indicates that is not the case, and we disagree. And he says, Mr. Barnard stated that there was no reason for Hanjin to draw any distinction between finance lease container losses and operating lease container losses. And in one sense, that's correct. That's what Mr. Barnard said. He didn't understand why Hanjin drew that distinction. But the fact that he didn't understand why, in the context of the bankruptcy, Hanjin drew that distinction is none to the point when the court is considering whether, in terms of the pattern of the losses, there is a distinction. They're completely different points. In that respect, I think my Lord Justice Phillips yesterday raised the issue of how one might, for example, trace these containers. And certainly my experience in containers is that there are two ways to trace containers. The first is they're all painted in very different bright colours. And certainly my recollection from when Hanjin was solvent is that Hanjin's containers were all painted a very bright blue colour, whereas Textainers are all painted a dark brown colour. And the second is that they all have a unique alphanumeric reference number. So the containers will all have a number on that is made up of letters that refer to the owner or operator and numbers that give you a unique number for that container. So insofar as it assists, that's my understanding and experience of how one traces containers. What I can't tell the court, but one could speculate, is whether the finance leases were painted in Hanjin's livery or in Textainer's livery. There's no evidence either way on that, and it would be speculation, but it's not speculation for me to postulate that possibility, because what I'm doing is testing my learned friend's hypothesis, so there's no reason to differentiate. It may well have been that the operating losses continue to be painted, operating leases continue to be painted brown and have a TEXU, which is Textainer's alphanumeric number. And I'm afraid I've scratched my head and racked my brain. I can't remember what Hanjin's was from the day they were solvent, but they certainly were blue containers. And so there are numerous grounds to think that there might be differences between the operating and finance lease losses. The judge gave other examples in his judgment, and again, my learned friend dismissed those as speculation, but in fact the reality is one is simply testing the merits of his inference. And then finally, at paragraph 88, his fifth point, my learned friend says that the Court of Appeal can legitimately draw inferences, and this goes back to the point my Lord Justice Arnold made. If it were appropriate to draw inferences, then because there's almost because there's such a lack of evidence, it would be equally appropriate for this court to consider the question as it was for the judge. I don't cavil from that, I can't cavil from that. But what I do say is that it isn't really appropriate for my learned friend to say, well, there's so little evidence available that it's equally appropriate for the Court of Appeal to draw inferences as the judge, when the only reason there's so little evidence available is because he hasn't put it in. And so for all those reasons, we would respectfully invite the court to conclude that the judge was correct to decline to draw the inferences my learned friend invited him to draw. And unless I can assist further on that point, I'll move on to the averaging point, if I may. On averaging, my learned friend starts his submissions in his skeleton at paragraph 92 by saying that there's a material difference between a non-marine stop-loss insurance and a marine container insurance. That is, in our respectful submission, a false starting point. For the reasons I submitted to the court yesterday, although the court is concerned with a programme of insurance that broadly relates to marine containers, this is not property insurance on marine containers, this is excess of loss insurance. And I showed you earlier today the passage from Arnold that essentially says the key distinction is not marine against non-marine, it's whether one is dealing with a programme of excess or layers or strata. In our submission, there is no material difference between the stop-loss insurance and the excess of loss insurance that is marine related. But the starting point is that we all agree that if Section 81 is engaged, then the averaging principle would apply. And my learned friend took the court through the work example in the Commonwealth yesterday. I don't propose to do so again because he did so very fairly. But in essence, if there is an underinsurance, then the recoveries are going to be shared proportionately between the insurer on the one hand and the uninsured owner on the other hand. But it's important to bear in mind that Commonwealth was a single insurer. So it's insurer on the one hand, insured on the other. And that will be important should it be necessary when I come to deal with the respondent's notice. But what is important is, again, as my learned friend very fairly said yesterday, there is another consequence of the possibility of the insured being underinsured. And he went through the example, I think he postulated a house that was underinsured. I don't think I have exactly the same figures as he has. But it's important because it goes to the amount you will be paid on your claim. So let's assume a ship rather than a house, because the ship is then marine insurance, so Section 81 is engaged. So as the editors of Arnold said, you have a presumption that you will average if there is underinsurance. If the ship is worth £2,000 but is insured for £1,000, if you suffer a loss of £1,000, you do not get paid £1,000 because you are treated as your own insurer for the top 1,000. So you get paid £500 against your loss of 1,000 by the insurers. The reason that's important is because if my learned friend were right, if this was a case of underinsurance, we would not have recovered in full from his clients. Now, that's not conclusive of the point. I accept that they may have paid more than they were obliged to. But the court is aware that all 5 lower layers, primary and the first 4, paid in full. The 5th layer declined to pay. My clients had to go commercial court proceedings, and after a mediation, the claim was settled. So the 5th layer are advised throughout this process. And although they didn't pay in full, that was, as I understand it, for various points to do with how the containers were valued and such like. There was no suggestion when the policies were paying that the principle of averaging set out in Section 81 was engaged. And if anybody at the time had considered, it could ask the court to turn up Section 81, which is at page 247 of the authority. So, Section 81, effective underinsurance, where the assured is insured for an amount less than the insurable value, or in the case of a value policy, not a case of an amount less than the policy valuation, deemed to be his own insurer in respect to the uninsured balance. So, as I said, and Melanie made the point yesterday, he would therefore not recover in full. It's complicated to work out exactly what proportions, and I'll come on to why later. But if there'd been any suggestion of underinsurance, none of it was paid out in full because of the averaging. And there wasn't. And the reason for that in our submission, Section 81, simply isn't engaged. And the primary reason for that is that in a policy such as this, and this harks back to what Lord Justice Staunton said, and harks back to what I said right at the beginning, is that you have 6 separate policies of insurance, each separately insuring a potential loss in an identified amount. When one analyses the programme as such, the correct conclusion is that for each slice, there is no underinsurance, because each slice is 5 million, or 10 million, or 20 million, and each insurance policy is for 5 million, 10 million, or 20 million. So on that analysis, looking at each policy individually, there's no underinsurance. It's only if one looks at the whole of my client's losses overall, including the losses over and above the layers of the programme, that one even starts to consider the question of underinsurance. But the crucial issue, and this is why I emphasised to the court, I think yesterday, Lord Justice Staunton saying that essentially one was looking at unlimited liabilities. And I'm going to now ask, there's one section of the Marine Insurance Act that didn't make its way into the court's bundle. My learned friend has kindly got some copies. I wonder if we could hand them up at this stage to look at. Section 16. Or if I could hand them up.
Thank you.
Section 81 that we were looking at compares the amount of the insurance to the insurable value. And the measure of insurable value is in fact defined at section 16 of the Act. And that's the 3rd page of the clip I've handed up. And subsection 1 deals with insurance on a ship. We're not concerned with that. Subsection 2 is insurance on freight. We're not concerned on that. Subsection 3 is insurance on goods and merchandise. Now, if we were talking about just the containers, we might be concerned with subsection 3, but we're not. The insured risk is the lessee's insolvency. We're talking about losses arising out of the lessee's insolvency. Subsection 4, in insurance on other subject matter, the insurable value is the amount at risk of the assured when the policy attaches. And that's why you can't define insurable value for the purposes of section 81. And if we were looking at goods, we still wouldn't be able to define insurable value, because even if you could define the value of the containers, you couldn't, at inception, define the insurable value of the potential loss of hire and so forth. What that does in our submission is to illustrate the fallacy of my learned friend's point, because where you are dealing with an excess of loss insurance program similar to professional indemnity insurance, for example, you have to define at inception what the total loss might be, and therefore asking oneself whether there is underinsurance is simply an inapposite question.
As regards the containers, you could look at the cost of the containers, but your point is that doesn't deal with the rental costs and the recovery costs.
It doesn't deal with the rental costs, the recovery costs, or the damages costs. So any of the other the limbs of the policy. And if one looked, my lady, at the insuring clause.
Yeah.
Page 167, one might be able to value lost equipment. But that's why I said to the court right at the outset that we were not concerned with, for example, a paradigm example where you're insuring a fleet. And I use the word fleet advisedly then because I knew I was going with this submission. If you have a fleet of ships, you might identify them all. If you have an identifiable group of containers where the property is being insured, one would expect to list the containers involved, perhaps by way of their alphanumeric reference numbers. But what we see is lost equipment, repair and associated costs, no way of predicting at inception what the repair and associated costs will be. Survey, damage, repair and remarking costs, again, no way of predicting at inception what that will be. Outstanding repairs and service charges, recovery, handling, drop-off costs, recovery and ransom charges, and then over the place, loss of earnings. None of those can be predicted at inception. So the Section 81 concept of an underinsurance based on insurable value simply doesn't work in the context of an excess of loss programme.
So you don't know how many containers you're going to have, and particularly not how many with a single.
Indeed, my lord. So even if one could list all the containers that Textainer owned, for the purposes of any occurrence, you don't know at inception how many are going to be on hire to Hanjin at any one time, and you don't know how many you're going to own. You may buy more during the course of the policy. And so, in simple summary, if one looks at the insurance slice of loss by slice of loss, there's no underinsurance. We're fully insured to each slice. If one takes a bigger picture view, the only respect which we can be uninsured is if you look at the potentially infinite liability. And that's why I said a few minutes ago when I was considering what might be paid if the insurers, had taken an averaging point, they would have had to say, well, by what amount are you underinsured? And it would have been no good them saying the amount of your loss is 103 million and the amount of the insurance is 85 million, because the amount of the loss would have been irrelevant for the purposes of Section 16. One would have had to say, well, what was the amount of your potential loss? And again, to come back to what Lord Justice Staunton said, infinite. And therefore one could never have worked out by what percentage my clients were uninsured if one approaches this as one should, as an excess of loss policy. And therefore you could never have engaged the averaging principle. And that's why in our submission it's simply wrong to say that Section 81 is engaged. That's why Lord Justice Staunton said that the passages in Goff and Jones and such like were not apt to cover an insurance by slices or layer or strata. And insofar as he didn't go the next stage and say, particularly where it's an excess of loss because the limit is infinite, we would respectfully submit he didn't need to go that far in Napier, but that is the logical conclusion of what he was saying. And so, for those reasons, I would have submitted to you without any further authority that Malone and Friends' averaging point is wrong. But of course, he accepted, and I'm not going to take you back to this, that what Lord Justice Staunton said in Napier is against him on this point, and what the learned editors of Arnold said in the passage I've taken the court to already is against him on this point.
But even if Section 68 did apply, all it says is you are the insurer for uninsured part of the loss. That's exactly the position which was analysed in Napier. So it just simply puts into the Napier analysis that you are treated as your own insurer for the excess and for the extra amount. And the difference here is it's treated as layers rather than insuring one ascertained piece of property.
My lord, yes, and that is why I said to the court, I think it was yesterday, that it's important that all of their lordships, both in the Court of Appeal and the House of Lords, approached Napier on the basis that it didn't really matter whether the retention and the slice above the stop-loss policy was self-insured by the name or insured by another insurance company. And Lord Templeman's example, he worked the example through assuming that all three layers that there were in Napier were all insured by different insurance companies.
So in other words, as though the provision of effective section 81 was given effect.
Exactly. The only respect in which it's not given effect is the Commonwealth respect. In other words, does the case of the Commonwealth then require you to
Yes.
pro rata
Yes.
rather than top down? So my lord is exactly right. So it's essentially the rationale of both Napier and in fact Artist Ricks in KAC was that this was insured. So the same as Section 81, treating the insured as self-insuring in respect of the top and the bottom slices. The only significance of averaging in the marine insurance context applying is that would enable my learned friend to say, well, on the authority of the Commonwealth, you have to distribute the recoveries pro rata rather than top down. And then we just come back to Napier again, where I say, well, that's wrong when you're dealing with slices or strata. It might be right if you've got a ship worth £1,300 and insured for 1,000, but it's not right where you have a policy of excess insurance.
Yes. Well, you say Lord Justice Staunton was right.
Absolutely. And the editors of Arnold, and Mr. Justice Ricks and Mr. Justice Langley, and for what it's worth, those who didn't advise KAC to appeal against Mr. Justice Ricks' decision on that point. And that then leaves me only to deal briefly, if I can, with the respondent's notice. If I'm wrong on averaging, then the Commonwealth approach applies, and the recoveries fall to be apportioned as between, in the Commonwealth, the insurance company that had insured the only slice of insurance, and the insured that bore the uninsured loss. My learned friend accepts at paragraph 35.3 of his skeleton, and I think he said as much yesterday as well, that the averaging point only arises if I'm right and you're taking a top-down approach. So if you're taking a top-down approach, he says, well, looking at that, then you have to apply averaging. The difficulty for him with that in our submission is that where you have a layer upon layer of insurance, so a programme, when you apply the Commonwealth, the way it would apply in these circumstances is that you would give a portion of the recoveries to the uninsured assured. So my client's Textainer in that capacity, they get their percentage. And a portion of the recoveries to the insurers who have written the package of insurance amounting to 80 million. So this issue didn't arise in the Commonwealth, but you are distinguishing between the insured part of the loss and the uninsured part of the loss. So the correct percentage to apply is what percentage is Textainers as uninsured, and that's 21,856,624 over 101,856,624.
So it's still then top down amongst the insurers.
And then amongst the insurers, it's still top down, because the premise of getting to the averaging point is that I was right on top down. And it's a very simple point, but if I'm right on that, the mathematical consequences is that I get the, forgive me, in round figures, 21/101ths as Textainer, and then top down within the programme, the fifth excess layer and the fourth excess layer would get the whole of the rest of the recoveries. My clients are the assignees of those insurers, so we get the whole of the recoveries. And so, in conclusion, my lords, my lady, firstly, top-down approach we submit, applied in Napier and KAC, was, quoting the learned deputy judge, firmly based on the fact that the excess cover was being provided in respect of aggregate losses. And when one appreciates that, it is in our submission obvious. applies to these policies. If any other approach had been considered at the time, it would have been of crucial importance, as my Lord Justice Arnold said yesterday, when considering the claim, to look at the dates. And that didn't happen because the policy was paying up. And therefore, the learned judge in our respectful submission was entirely correct to conclude that the claimants had not discharged the factual burden of proving their case. And as the learned judge said at paragraph 107, this was not a case where relevant details and evidence were not available to them. On the contrary, they're available, but have not been relied on. And if one looks at whether the learned deputy judge's decision was correct, he had manifestly applied the right test as to whether to draw an inference, and he decided not to, correctly in our view. In relation to averaging, the learned deputy judge was entirely correct, following Lord Justice Staunton and Napier, to say that none of the points my learned friend has made, any more than any of the points that the Court of Appeal looked at in Napier, touched upon insurance effected on a layer, slice or strata basis, and therefore the averaging point doesn't apply. But even if it did, it doesn't assist my learned friend, because mathematically my clients are still entitled to retain the whole of the recoveries. Can I just check the note I was handed? My lords, my lady, unless I can insist further, those are our submissions in support of the brief.
Thank you. Any reply?
My lords and my lady, there's much to reply to. I'll do it as concisely as I can. I won't trespass into remaking submissions. Of course, if I do, I'm sure you'll be the first to let me know I'm doing it. I should make it clear, just to clarify the position at the end of my submissions yesterday, I accept what my learned friend says, that issue 3 is independent of issues 1 and 2. It's not dependent on issue 2. So insofar as I said that yesterday, I can only claim that was subject to a mental fog on my part, but it's an independent issue and it arises independently. The schedule of losses which are referred to by my learned friend at the supplementary bundle, tab 5, I ask you to turn that up. And it's fair to say during my submissions yesterday, I didn't refer to this document. I did refer to the schedule which was attached to the claim letter against Hanjin. And of course, and I appreciate the court will be aware of this, the Hanjin claim letter schedule is as at February 2017, whereas the figures in this schedule, which is the basis of the insurance claim against the insurance program, is at 9 months later, 7 months later was September 2017, and again March 2018. But one needs, and I think I may have made a misrepresentation unwittingly when I referred only to the schedule and identifying that the large proportion of the Hanjin claim schedule in relation to lost containers, whereas of course the proportion here is much lower. And that presumably is because a number of the containers were recovered in the meantime. But I don't think anything turns on that. It is worth noting the 4 categories or heads of loss which are claimed in this schedule. You have loss of revenue, you've got unrecovered units, and again, of course, they're totally lost units. And you can see by reference to underneath, it says unrecovered units, NBV, that's net book value of operating lease units, and unamortized principal of finance lease units. But the actual figures don't distinguish between finance lease and operating lease units. Thirdly, you've got recovery costs. And fourth, you've got repair costs. And it's just useful to have those heads of loss in mind, because it will be relevant when I come back to deal with certain submissions which my learned friend made. But what we say is, of course, that nothing in this schedule alters the submissions or the analysis which I deployed yesterday. My learned friend, and this is touched on in various aspects of his submissions, both yesterday and today, and on the different issues, question whether or not this particular policy or policies were in fact property insurance. and they are property insurance. And if I could I explain why I say that. And I think it's useful to bring up the policy, which is at the core bundle tab 13. The first thing to know is that at page 165, you have the principal insuring provision, which is section 1, headed physical damage and equipment recovery. The very essence of property insurance, whether it's a single ship or 100,000 containers or more, is that it's insuring against loss of or damage to property. And this is exactly what this insuring provision does. And I'll explain, my learned friend says this provision itself is limited. I disagree, and I'm going to explain why. But when one considers a classic marine insurance on a ship, that will insure loss of or damage to the vessel, but will insure additional things as well. For example, it will insure particular types of costs, which would be including sue and labour costs, which are mitigation costs, general average costs, salvage charges, and the like. Indeed, in cargo insurance, you'll also have often provisions dealing with freight forwarding costs or forwarding costs. And so the fact that there is a cost element in the property insurance doesn't detract from the fact it is a property insurance. Now, just looking at the...
This doesn't apply while it's on hire.
Well, I don't know why that's said.
It says, whilst being moved, delivered or repositioned, or whilst located in depots or otherwise in store. So it covers you, Textainer, while they're moving their own containers, while delivering them, reposition them, and when they're in the depots, but not when they're on hire to the lessee.
Doesn't say that, my lord. With respect, it doesn't say that. What this is my learned friend's quite right. Without this,
isn't that the whole point of 167? In respect of on-hire equipment, the insurers will identify the assured to the extent provided by this policy.
But my lord, that's an extension. It is not. It does not. It is an extension. It's supplementary cover.
Well, the whole point you have extension is because it's not under the primary cover. Otherwise, you wouldn't need it.
Well, what you don't, my lord, forgive me, but what you don't see in the extension is any, as my learned friend accepted yesterday, any promise of indemnity for loss of the containers. And even when it comes to damage to the containers, there's restricted cover. The only unadulterated cover when it comes to ensuring loss of or damage to property is at page 165, not 167. All that the extension does is to deal with a particular type of container and a particular type of cost. The only losses referred to in items 1, 2, 3, 4, and 5 at page 167 are costs, not loss of or damage to property. When one goes back to the insuring provision, my lord, there is no suggestion whatsoever that this is limited to off-hire equipment, if that's the suggestion. It applies to both. And the reference to moved merely means that it's in transit, whether it's on a ship or elsewhere, or for delivery purposes. And it says delivered, it says repositioned, it says located in depots, which just means storage facilities, according to the definition, or otherwise in store anywhere in the world. There is no restriction by reference to it being off-hire equipment. It covers all the normal risks associated with containers. And my learned friend would be in a very difficult position to claim for a total loss in relation to on-hire equipment when that's not even, if this was not restricted, if this was restricted to off-hire equipment.
Well, the exclusion 8 excludes, it says other than the lessee. That wouldn't be necessary unless this covered on-hire containers.
Well, that is, that may be, but what that means is you still have cover for loss of or damage to containers. If, however, the container is lost by virtue of financial default, then I agree the exclusion may well apply. But that doesn't necessarily mean that it doesn't cover on-hire equipment. In fact, the fact that the exclusion is there suggests it does cover on-hire equipment.
That's what I'm saying.
Yep.
Yes.
So, that's important. And one then looks at page 166, which talks about basis of valuation and indemnity. And it's the basis of valuation of equipment under this policy for claims and declaration purposes is for equipment owned by the assured, which is the assured's depreciated book value. And claims shall be payable at reasonable cost of repair or replacement, but this is the important part, but not exceeding the lesser of the basis of valuation clause as defined above, or the market value of affected equipment, including all freight and similar charges. So what that does is demonstrate that there is a valuation, contrary to my learned friend's recent submission, which is somehow maybe an unvalued policy. This is a valued policy with the book value representing the value of the container, which was in fact, that's why I referred to in the loss schedule, refers to the net book value. And what the valuation does is operate as an internal limit for the container in question for any costs associated or any claims which are associated with that. Because it refers to, in the claim shall be payable at the reasonable cost of repair or replacement, but not exceeding the lesser of the basis valuation as defined as market value, including all freight and similar charges. Then we have the extensions, and it's just useful going through the policy. And 167, we have, this is an extension which is applicable to on-hire equipment. And so, of course, off-hire equipment would not attract cover under this provision, which goes without saying. My learned friend, I think, placed emphasis on the last, or the second last paragraph, which says, caused by or arising from the failure of any lessee to fulfill their obligations with respect to such equipment, including such costs and expenses incurred by any lessee and transferred to the assured, etc. Now, the 183-day provision, as I indicated, or at least preempted yesterday, is referring only to the relevant costs and expenses incurred by the lessee and transferred to the insured. So that attaches to the words including such costs. It doesn't attach to the opening words. And we know that because the 183-day provisions is also referred to in item 1, but not repeated in item 2, 3, 4, or 5. So insofar as any attempt is to put to extract any value from that provision, it's just inapplicable and it's limited. Now, one has to look also at the notion here. When we talk about damage to containers, we are speaking of essentially which is not a total loss. We're talking about the cost of repair. That's how the loss translates itself. That's how much the indemnity will pay. Now, 2 points I wish to make about that. If you look at the cost of repair referred to in items 1 and 2 and 3, which I don't think they're referred to in items 4 or 5, they're limited. They're not open-ended costs of repair. So the first one is costs incurred in retrieving and or repairing equipment abandoned by the lessee. And also it says an outstanding repair costs incurred by the lessee. So not incurred by the Hanjin, but by the lessee. Sorry, but not incurred by Textainer, but the lessee. Item 2 is repair and remarking costs, including survey and inspection charges incurred by the insured in accessing and the extent of damage insured under 1 above. So that's cross-referring to 1. And then thirdly, repair and service charges relating to the equipment raised by the insured to the lessee after the date of the occurrence. So these only relate to repair charges essentially invoiced or charged to the lessee after the date of the occurrence. Now, the important thing to note about the 4 heads of loss which we are considering, and this goes back to issue 2. Now, I'll come back, well, let me come back to it. It's probably more efficient. My learned friend yesterday indicated that he seemed to use the terms property insurance in excess of loss insurance as if they were diametrically opposed. They're not. They're 2 different descriptions dealing with different things. This is a property insurance for the reasons I've already expressed. It's not a liability insurance. It's not a financial loss insurance, except in relation to rental charges. But property insurance, to describe something as property insurance, is merely to describe the subject matter of the insurance, what is being insured. Excessive loss insurance is not concerned with the subject matter insurance, it's concerned with the mode or method of insurance. How are you insuring it? How does one work out what the limits of recovery under each policy are? So just because it's excessive loss insurance doesn't detract from the fact that it's a property insurance. Then I think my learned friend indicated that the 183-day provision, also we've got the date of the preliminary claim provision and the date of final claim provision. And of course, we have no indication of what the preliminary claim or a preliminary claim was even submitted. But what is clear is that these terms are not used anywhere else in the policy. But even if they were, their definitions do not impinge on the nature of the obligation of indemnity, in the sense that they don't tell you anything about when the right to an indemnity by way of loss under this insurance policy will accrue. But the fact they're not even used in the policy or the operative provisions really makes them almost irrelevant for these purposes. And as far as the rental charges provision of page 168, item 3, the proviso, the maximum liability of the insurers under this section, it says, shall be the lesser of 183 days equivalent charges per unit of equipment subsequent to the date of occurrence, or any other limit specified herein. That does nothing, that doesn't regulate anything other than impose a limit of recovery. It doesn't tell you when or whether you have a right of indemnity. The existence or non-existence of a drop-down clause is irrelevant for these purposes. The classic drop-down clause, all that means is if you've got a primary policy and an excess policy, if the primary policy pays out, when you have the next unrelated claim, that's when the excess policy will drop down, if there is such a provision, so to take the place of the primary insurance. But in the case when you're dealing with losses which arise out of one occurrence, which is common ground in this case, the existence of a drop-down clause or otherwise is irrelevant. So my learned friend's reliance on the fact that the excess policies don't have a drop-down clause takes the court no further in either direction.
I think my point was that they do have a drop-down, a no drop-down clause.
I think that's what I said, but if I didn't say that, that's what I meant. Thank you for the correction. Now, I've explained why I think there's a distinction between the stop-loss property in Napier and Hunter and the insurance policy in this case, or the policies in this case. I mean, in a nutshell, if I could just respond to my learned friend, I think, accepted yesterday that in Napier and Hunter, no cause of action arises under the policy in that case until the 36th month, the end of the 36th month. Now, that concession alone would indicate there is a very substantial distinction between the policies in this case and the policy in Napier and Hunter, because it's only when each and every loss accrues or occurs that an independent cause of action accrues. And of course, in Napier and Hunter, the losses were confined to a single point of time for the determination. In this case, losses are evolving over time. Even with totally lost containers, if they're recovered, that loss will alter over time. But we have a completely fluid scenario of what losses are occurring at different times. So in short, in Napier and Hunter, there's only one type of loss being insured against at one point of time, and for those purposes, I say it's a single loss. In this case, we've got multiple losses occurring and different heads of loss, total losses, damage to property, cost of recovery, loss of rental, all of them insured under this policy. So my learned friend relied on his reality check, and then I think also an additional reality check, which and for this purpose, I'm cross-referring to paragraphs 70 and 96 of the learned judge's judgment below. The reality check as I think I tried to indicate clumsily yesterday, doesn't work very well. This is the notion that what happens if the recovery is made before the date of the payout of the indemnity under the policy. And that works brilliantly when you're dealing with a single loss. When you're dealing with a single loss, if I have a property which is worth £1,000 and I recover, as the insured, recover £600 before the insurance payout, that means my loss is reduced to 400, and that's all I can recover from the insurer. By contrast, if I recover that after the insurance payout of £1,000, then that £600 goes to the insurer, and that's how you test it, and there's a symmetry to that. The difficulty when you have multiple losses being insured, even if it doesn't have to be excess loss program, but multiple losses, so you could have 10 losses being insured in a policy period by a single layer policy. In that event, if there's a recovery in relation to the first loss prior to payment of the insurance indemnity, that means that loss disappears or is reduced, and therefore the insurer is relieved of that obligation. But then because the limit has been freed up again, the obligation goes to the second loss and the third loss. So it's a transfer of responsibility from one loss to the other, which of course you don't get into when you're dealing with a single loss. There is a material difference, and the reality check just doesn't apply in these circumstances. And as far as the additional reality check, which is referred to by the learned judge at paragraph 96, or I think it's my learned friend's phrase, the additional reality check, this gives rise to a complicated question as to the impact of when a loss is paid out by the insurer and there's a subsequent recovery. Does that itself free up the limit, or does it exhaust the limit to that extent forever after? And that's not, as far as I'm aware, a matter which has been determined by the court. It's still an open issue. But insofar as the learned judge is right, then of course it's a matter which has to be taken into account. But I'd say for this purpose, it's an irrelevant consideration. And for what it's worth, we say that the recoveries condition doesn't alter the position. It's entirely orthodox. Sorry, my lord and my lady. I am trying to go as quickly as I can. So, and I'm relying upon you to tell me if I'm repeating submissions. I'm not intending to. My learned friend spoke in terms of the primary insurers or the excess insurers' obligations of indemnity to crystallizing, if that's the right word, once the threshold, so that once the £5 million or dollar retention's exhausted, or once the primary limit is exhausted, etc. That's not quite the right way of looking at it with respect. There's no crystallization of a cause of action in that sense. What the right way of looking at it is, as each and every loss occurs, there is if it falls within the retention, then that erodes the retention until you get to the threshold entering into the primary policy. Once it hits the primary policy, as and when each loss which impacts that primary policy occurs, that will give rise to a right of indemnity against the primary insurer, and that will erode the primary insurer's obligations or limit until it gets to the $5 million limit under the primary policy. And then you repeat the exercise as you go up the chain. Just in case it's relevant, the cause of action against the insurers arises on the occurrence of the loss, not the occurrence of the insured peril. So even though I may have referred, for example, for purposes of extension, that the on-hire equipment extension, that the financial default of the lessee is an insured peril, the mere existence of the insured peril doesn't engage cover. What engages cover, in the sense of what gives rise to the right to an indemnity, is a loss caused by that event. I'll add that nothing in the notification provisions or claims conditions affect the obligation of indemnity. They're just, in the sense of, they're provisions which require notification to the insurer, but they don't tell you when or whether the obligation of indemnity arises in answer to a cost, in answer to a loss. I didn't. I may be misrepresenting my learned friend's submission. I didn't mean to. If I've just may not correctly have understood it, but it is very possible that the one individual container, can give rise to a variety of losses. For example, loss of earnings, cost of recovery. Now that doesn't mean you can't recover in relation to that one container both those heads of loss. Of course you can, but it does mean that if the loss of earnings occur in October 2016 and the cost of recovery occur in February 2017, those two costs are indemnifiable, but the right to indemnity arises at that point of time, not any other different. So there's two causes of action in relation to the one container. Now, I think my learned friend, and I think with respect, the court on occasion referred to how the parties have handled the claim and how they approached the claim and how they looked at it, etc. And that's, of course, I understand why that's being referred to, but that doesn't impact, unless it was in a case for a estoppel or a estoppel by convention of some sort, and there wasn't a estoppel by convention argument advanced by Textainer below, which was dismissed in a different context, I should say, was dismissed by the judge below. But unless there was going to be some sort of estoppel argument, that doesn't really affect the way this policy operates according to its terms. Now, I think I owe an apology to Mr. Justice Langley, in the sense of I say Mr. Justice Langley's decision was wrong, and I think it is wrong in one sense, but it seems to be Mr. Justice Ricks's decision that the top-down principle applied. And then to that extent, insofar as it concerns non-marine insurance, I say it's wrong. But if one looks at the decision in KAC against Q8 Insurance involving, before Mr. Justice Langley, the arguments which were deployed by the insurers seem to be jolly close to the argument that top-down principles shouldn't apply. So it's very hard to distinguish the two. But it is entirely right to say, and my learned friend was right to say, that Mr. Justice Langley's role was to apply the top-down principle. And it was no dispute between the parties that that was the case. And that's at page 182 of the authorities bundle. That helps my lords and my lady. Now, as far as my learned friend relied upon the Arnold commentary, I think it's in relation to issue 1, but also in relation to issue 3. This is at paragraph 31-46, where there's an analysis between looking at Napier and Hunter and the averaging principle and saying, basically identifying what they consider the principles to be. And of course, I have nothing but respect for the editors of Arnold. They do conclude that conclusion by saying this is not free from doubt. And what I would say is that the precise difficulties or issues which have arisen in this particular case before this court was not something which was being considered by the editors of Arnold. So if I could come on to, that's issue 1, unless there are any questions about issue 1. If I can come on to issue 2. Issue 2, if I strayed in a moment of over-exuberance yesterday by asserting that the spreadsheets did not contain dates of loss, that was an error on my part. I didn't mean to do that. I meant to confine myself to my submission of paragraph 77 of my skeleton, which was there was no evidence before the court that the spreadsheets in question contained the dates of loss. It's probably worth just looking at Mr. Railton's judgment at paragraph 102 onwards. Page 110. 102. Having rejected my submissions about the distribution of the recoveries, therefore applying the top-down basis. At 102, the judge goes on to say, this conclusion makes it unnecessary to consider the methods proposed by the claimants for connecting particular losses indemnified by particular policies to particular recoveries. if that were to be a relevant exercise to undertake, I would agree with the claimants that insofar as the relevant timing of it could be determined, each individual loss would contribute to the erosion of the retention and then the limits of the primary and excess policies in the chronological order in which it was suffered. I also agree that it would be a matter for evidence to when each particular loss was suffered. And then what Mr. Railton does at paragraph 104 is to refer to the spreadsheets. And then I think he confines himself to the spreadsheet and the material before him. And of course, the spreadsheets weren't before the judge. And in paragraph 107, he concludes, and which my learned friend just referred to, I agree with the Textainer that was for the claimants to establish the factual premise on which their claim is based. And in my view, they have not done so in this respect. This is not a case where the relevant details and evidence are not available to them. On the contrary, they are available. They have not been relied upon for these purposes. Now, my submission is, firstly, that he's referring only to the spreadsheet. There was nothing else to refer to. And my point of my appeal is there's no evidence before the court that the spreadsheet contained the dates of loss. My learned friend today asserted that my clients had all the relevant materials available in order to identify the dates of loss. Now, my first submission is there's no evidence of that before this court. The second submission is if one looks at each head of loss and considers what my learned friend is saying, let's consider this. So in relation to the total loss of containers, the loss arises and is indemnifiable when either becomes unlikely or impossible to recover the containers. That's not something which would naturally be referred to in the invoices which my learned friend referred to. That's a question of fact in each circumstances. The only information we got was that after 12 months in September 2017, this is how many containers have been lost, not the dates on which they're lost in terms of it. So that's all that's referred to in the schedule of loss. The second head of loss is damage, the cost of repair. Now, the costs of repair are not incurred, the entitlement to an indemnity in the cost of repair is not when the costs are incurred. It's when the damage to the container occurs. Now, this was made good by the decision of His Honour Judge Pelling in the Griffiths case, which I took you to yesterday, where the argument was, in that case, where there was damage to property, or that it was a non-marine insurance, I should add, that it was done for limitation purposes, that the right to indemnity accrued when the expenses were incurred. But the judge rejected that, says no, it's when the damage occurred, it's when the loss occurs in terms of property insurance. And that's what Sir Peter Webster said in Callaghan and Thompson. It doesn't matter when there's damage to property. You can't quantify the loss because you don't know what the cost of repair will be. The cause of action accrues upon the infliction of damage to the property. So again, if the damage is occurring to containers, that's not something which I dare say Textainer is not aware of, nor are my clients aware of. What we may know is where repair costs are incurred, but that's not the relevant date. The relevant date is the incurring of damage. And I would invite my lords and my lady to refer to the decision in Griffiths, the Liberty. I mean, for the sake of time, I'm not going to take you to it, but it's paragraphs. I did take you to 14 yesterday, but if one looks at 15 to 18 as well, which are the conceding paragraphs, that explains the position. Then we've got the third head of loss is cost of recovery. Now, I fully accept that insofar as there's evidence of invoicing, which itself is not the evidence of losses, but it's the payment of those costs, that may well be something which could have been advanced, insofar as we had the invoices, although I say there's no evidence before the court if we had all the relevant invoices now. And the fourth point is rental charges. Now, as far as rental charges are concerned, we do have an indication of how the rental charges were incurred by reference to the schedule which was attached to the claims made against Tangent. But I've made my submissions about it. I'm not going to repeat them now, but at least that they're broken down month by month. My learned friend makes the point, well, the finance lease container rental charges are higher. Well, they are higher by 30%. But in the scheme of the policies which my clients are insuring, which covers $40 million, that's small beer when it comes to whether or not they fall within the scope of those policies. Now, one considers when one considers the impact of the learned judge's judgment below, where he says there's no evidence as to, if you like, the pattern on which the losses occurred by reference to operating lease containers on the one hand and finance lease containers on the other hand. And therefore, my clients have not discharged the burden of proof. What that indicates, essentially, is this, that there's no evidence that even a single operating lease container was indemnified by my clients under $40 million worth of cover available. That seems highly unlikely. The reality is, given the size of the claim, given the number of the containers, given the different types of loss, and given that the fact that the total losses and damage may have occurred on dates which are unknown to my clients, there is no way any evidence could have been adduced to address those issues in a way which would actually be satisfactory. And therefore, in those circumstances, the inference which I invite the court to make is entirely appropriate. I think my Lord Justice Phillips referred to the adverse inference going the other way earlier today, and of course that's true, but that's very much in specific circumstances. There's no invitation by Textainer that such an inference should be drawn, not in the skeleton arguments anyway. What I would say is this, that that's often in relation to witnesses rather than documentary evidence. But I'm not addressing it in any detail because I don't think there's any role for it to play in this particular instance. I think, therefore, I can go on to the third issue. I'll be 5, 6, 7 minutes. I hope that's the third issue is, of course, averaging. And I start out by acknowledging that there is contrary opinion, and I have to deal with that, and I understand that. And all I really want to, the only point I really want to make are 2 points, I think. The first point, or 3 points, I should say. The first point is that if one just had one policy, and it was, let's just say it wasn't, these weren't 6 policies insuring between 5 and 85 million, but it was one policy for $85 million. And in fact, all the containers at risk, which are knowable because all the relevant containers are at risk, they're identifiable class, which are insured on this policy, whatever they are. Let's say they're worth $100 million. There is therefore underinsurance. And by adopting Section 81, and I appreciate Section 81 just uses coded language of the assured is his own insurer for the uninsured element, but the way that's been interpreted by the courts and by the editors of Arnold and others is that this gives rise to the averaging principle, which is peculiar, if you like, to marine insurance, not to non-marine insurance. Now, if you had a single policy for $85 million and it was a $100 million policy, then you would be in the realm of averaging. And my submission is the mere fact that that one single policy is divided into 6 doesn't change that analysis.
What do you mean by 85 million for 100 million containers? Because 85 million is in relation to a single lessee, isn't it?
No, 85 million is for, well, just for the sake of argument, it was $85 million worth of cover for a specified class of containers, which is containers operated or owned by Textainer. So even though there is a very large number, that's what's potentially.
I thought the limits in relation to the aggregate limits for more than one.
They may well be.
Was much higher.
They may well be, but just for the sake of argument, in terms of.
But is there any suggestion here that the value of the containers exceeded 85 million? least.
Oh, I see what you mean. Well, the point I would make is this, that when one looks at a normal marine insurance on hull, on ship, you have an insured value, and the insured value operates as the limit of whatever is recoverable, whether in relation to cost of repair, total loss, or other costs which are insured under the policy, such as general average or salvage charges, or forwarding charges under a cargo policy. So even though I split the losses in different ways, there is a limit when it comes to how much is recoverable, and that limit is set by reference.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Thomas More building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
Now you have to wait for it to be repeated.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Thomas More building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
Now we have to hope that there's no further repetition.
I'm not going to take it personally. Sorry.
Because my learned friend was interrupted in his reply submissions before the learned judge, where we did have to evacuate the rolls.
Did we? I forgot that. Did
Yeah, we got evacuated,
okay.
didn't we?
I'll proceed if that's.
Yes, please do.
So in a sense, the fact that there is this internal limit means that there must have been an underinsurance. With how the aggregate limit applies is different, but here we've got $100 million of losses. And assuming, I mean, you may be right, but on the eyes, my submission, I don't think you are, but my submission is that there is underinsurance in these circumstances because you've got this internal limit. And just to address a point my learned friend made, I think my learned friend may have been going down the route of referring to Section 16 of the Marine Insurance Act on the basis this is an unvalued policy, but it's not. It's a valued policy because of the basis evaluation clause, which I referred to at page 166.
Sorry, but you're not saying that that basis evaluation clause affects every sort of claim under the policy. It's only certain types of claims, isn't it?
Well, it can well operate as, in the ordinary way of marine insurance, an insured value operates as the limit for any recovery under the policy. But insofar as it goes beyond that, it may be, but my submission is based on the fact that there is an agreed valuation, and I think it's under section, say, for 69 of the Marine Insurance Act, which is not before the court, which indicates what the value is, that the value operates as a limit. Sorry, I beg your pardon, section 68 of the Marine Insurance Act states that it operates as a limit. That in those circumstances, I submit it is a limit, but if that's wrong, then I'm wrong on that point. But it's certainly an agreed valuation provision. It's not an unvalued policy. Going back to my original point is if you've got one policy, just assume I'm right and it's under insurance, and assume it's that there's $100 million worth of containers, but there's only $85 million worth of cover. That would be under insurance. And my only point is that analysis doesn't change just because you have 6 policies rather than 1. And then finally, my learned friend's response notice point. It would be very odd that averaging applies as a matter of law to a single policy, but shouldn't apply generally across the board. So there would be no room, I would submit, for a top-down exception to the averaging principle in the circumstances suggested by my learned friend. Averaging applies throughout and affects all parties concerned, not just the insured versus the insurer. If I could just check if there's anything else I need to address.
So that's a novel point, is it? One that
Entirely novel. I mean, as far as I'm aware, since Mr. Justice Ricks's speculation and Lord Justice Staunton's comment in Napier and Hunter, I don't think this issue has been touched on or dealt with by any court. I don't know if my learned friend, he agrees. So I would like to end on that point of consensus, just for the benefit of all. But unless I can help my lords and my lady further, they are my submissions.
No, thank you very much for your interesting submissions and those supporting you. We will consider our judgments. They will be handed down in the usual way, that is to say they will go in draft to those on the circulation list under strict embargo, which must be observed for the purpose only of correcting typographical errors and the like, and not for the purpose of re-arguing the case. And please, at that point, try and agree a consequential order. If you're unable to agree, put in brief written submissions and we will decide the consequential order on paper. No further attendance will be required.